Ready.
Ready?
Mm-hmm.
Hi, this is Lisa DeMonte with MyLegal.com. It's Thursday, May 6th, and we're here in Washington, D.C. for the American Bar Association Second Annual National Institute on Internal Corporate Investigations and Forum for In-House Counsel. And with me this afternoon is Steve Solow, who is a partner at Counsel. Welcome, Steve. Thanks for joining us. Steve is the firm's, or is chair of the firm's environmental litigation practice and co-chair of the white-collar criminal and civil litigation and compliance practice in the Washington, D.C. office of Cat & Muchin. Steve, you were just part of a panel on discussing the ethical issues in internal investigations. It seemed that there were several key issues that were discussed on the panel or part of the group here. And several of those were having a plan, independence, having a clear engagement letter, preservation of confidentiality, and privacy in the workplace. So would you mind just touching upon one or more of those issues and sharing with our listeners some of the salient points of the discussion?
The goal of these conferences is to give practical advice to people who have to deal with issues on a daily basis. And one of the hardest things for in-house counsel, particularly, is balancing the competing demands of their management, managing outside counsel, and dealing with the government in the case of an external investigation, which is primarily what we were talking about. And some of the key things that we talked about today were the need to have a really good, clear engagement letter that defines the scope of the representation. And one of the reasons for that is every time you do any one of these kind of matters where you're dealing with an outside investigation, you have to remember you're both handling the internal issues that you're dealing with, and it may be looked at a third party in the future and looked at critically to see whether you were really doing what you needed to do. So something as simple and everyday as a retention letter becomes important because it goes to the scope of the investigation, where you're adequately looking at what needed to be looked at in order to get at the issues. The other issue we talked about, one of the other issues we talked about was the sort of the Miranda warnings. It's called the corporate Miranda warning. And the issue there was to simply be able to make clear that you had satisfied your ethical obligations, and particularly mentioned rules 4.3 and 4.4 of the model rules, and looking at those before you undertake to give someone a corporate Miranda warning, and making sure you're giving them an appropriate statement and you're not offering them legal advice when you're actually representing the company. And the last thing we talked about, and was sort of an overarching theme of this, was to be prepared, to have planned for a sort of unexpected situation where there's a subpoena, a search warrant, a whistleblower, and so it's not the first time you're considering issues like how do we collect our electronically stored information, making sure you don't run afoul of any privacy rights that your employees may have, and so that you're responding in a planned, orderly way to all those issues, whether you're doing the investigation yourself internally or involving outside counsel.
Steve, obviously many ethical or many facets to these ethical considerations. So thank you very much for taking the time to explain and share those with our readers. Thank you.
Thanks very much.